In this week's episode of the Jhana podcast series, we sit down with Mridul, who's been a partner at Trilegal working on real estate for the past 17 years. We had a very interesting and exciting conversation about the very good reasons why real estate in India is so difficult and what is already happening to fix it, what you as a consumer should beware of when you buy, and what needs to be done in the ecosystem at large. When you listen to today's conversation, I'd like you to borrow from Gavande's beautiful book on public health, The Checklist Manifesto. There, Gavande describes public health problems as essentially simple, complicated, or complex. Simple and complicated problems are those problems where we have the treatment sets, we have the order protocols, we know what to do, but it's difficult to orchestrate at population scale. We just need too many resources, too many people have to show up in the right place at the right time and do the right thing. Whereas complex problems are problems where we don't quite know what to do, where we maybe don't even understand the disease. Problems like cancer rather than tuberculosis, where we're still hunting for diagnoses rather than thinking about how to orchestrate public health and efficient systems at scale. So today's conversation goes through the same context in real estate and property transfers and leasing. Think about which of these problems sound like checklists gone too long, gone too awry, that you'd rather have a computer, a form operator, or some kind of machine do for you, and which of these are complex, difficult, truly intellectually confusing problems that require bright minds like Mridul. We're very happy to share this episode with you.
Pleasure to have you, Mridul.
Thank you for having me.
So, we're all been recently looking at the Supreme Court judgment in the Mahnoor Fatima case, where it was stated, or rather it came across all the media channels, where they said that possession of a registered sale deed is not really proof of ownership. And I think this really got everyone a little worried. So we really wanted to kind of unpack that at one level, and also at a broader level just kind of talk about the issues that plague ordinary citizens in their real estate transactions, and how does tech, because we are a tech company, a legal tech AI company, how does tech play into the real estate sector in India? We have Mridul Kumbalath with us, a partner at Trilegal. For 17 years, he has practiced in the real estate space, so essentially a lot of experience. So we're very happy to help break this down with us today. Thank you for joining us.
Thank you for having me. So happy to be part of this episode with you guys, and thank you for inviting me.
No, it's a pleasure to have you. And maybe a great place to get started is 17 years of real estate. In my view, is a lot of real estate. How does one get there, and what were the choices that made you a lawyer and a real estate lawyer specifically?
So
how did you choose real estate? Because it's not a common choice for most aspiring law graduates.
So I am a fourth generation lawyer in the family, and law is something that I kept seeing growing up because my dad was a practicing lawyer as well, and therefore I ended up with law. Real estate was specific and out of choice because straight out of campus, there were two options given my way: to do financing or to do real estate. And I chose real estate because real estate has a lot of interface with civil law.
Where did these options get given?
These options got given during your campus placements.
Okay, got it.
And I chose real estate, like I said, for the reason that there's a lot of interface with civil law. And civil law is something that, whether corporate or not corporate, you always need it in your day-to-day life, which includes the cases that you're currently intending to discuss with me. And that's how I chose real estate, because at any point in time you can go back into civil practice, court work, etc. And the general practice of real estate exposes you to all these kind of laws, which has a lot of interplay with our day-to-day lives. So that's how I ended up doing real estate. I started my career in Bombay, and since 2013, I've been in Bangalore. A lot of people ask me, how do you manage real estate without knowing the local language? So my answer to that is, knowing the local language is only to gather facts. But ultimately what's important is the law, which is uniform across the country. to a
And-
large extent.
And almost the role of a lawyer starts after the role of an auditor ends, when the veracity and sort of integrity of documents is assured and you are not worried about the truthfulness of a signature almost.
Yeah, but see, the good thing about legal practice and your training is also to ensure that you don't need to come up to that stage.
Right.
Something that we as lawyers are trained during the several years at law school, during our internships, as well as during our practice, is to have an eye for detail.
Yeah.
And therefore, of course, we are not auditors to catch fraud, match signatures, but we are very due diligent. Most
Right.
lawyers are.
Right.
And therefore, a lot of these issues that people at later stages encounter in terms of forged signatures or signatures missing in documents, those are things that we try and catch early on as part of our training. And
that's because there's sort of a smoke trail that you've been taught to chase. And
yeah,
intuitively-
we've always been taught to have eye for detail.
Right.
Devil is in the detail. And that's why I said language has never been a barrier.
Yeah.
And now you have a lot of
Translation tools.
translation tools in the market, which a lot of lawyers are using, including a Google Lens, to read all kinds of languages, which at least most lawyers that I know actively use this.
Yeah.
So language is no longer a barrier, and therefore you can practice whether it's in Maharashtra, Gujarat, Kerala, Karnataka. So language has never been a barrier. But what is most important is knowing the law. And I firmly believe that, because most errors that happen during transactions where people don't engage lawyers, etc., is because people do things without knowing the law. It's like self-medication. You don't want to go see a doctor. You look up something on the internet and then self-medicate. But the end result may be that you may have some other complications, side effects, things like that.
So what causes this? Is it just that for most people the cost of procedure is greater than the expected reward, or are people not realizing something? Like, what's your theory for?
Or do they feel lawyers are
I think law is also to partly blame in it,
Right.
because the law also mandates that nobody can claim ignorance of the law. So everybody at some level also believes that law is law. We all know it.
Right.
So they don't attribute the importance that it needs to be given to it. So I think that is one of the reasons why people take it easy.
But this is almost like one of the common things I keep pushing back on lawyers, right? Because I think there's an inside-outside view here. Now, I'm sort of a business principal, you're a lawyer, so this actually works quite well as a positionality. Where for me, law is the cost of performance. It's merely the cost of its procedure, right? It's, for example, if I have a transaction, the transaction occurs in my head where the handshake occurs. And everything afterwards is just securing and ensuring and de-risking that transaction.
Yeah, it's not, I would agree with you to some extent, but it's not completely true. Had law not been there, transactions wouldn't have occurred.
Right.
Because law is what lays down the rules of engagement. And unless you have those rules of engagement and those are respected, there is no sanctity to these handshakes that you're talking about. So therefore, knowing those procedural aspects and giving them also the importance that they deserve becomes paramount. And that is case in example of the case that you intend to discuss with me. Of course, the case did not expound anything in great detail on real estate law or how title verifications need to happen. But it did talk about one interesting aspect. So
Please jump right in, because that was our first question.
Let's get into real estate.
So maybe I'll just give you a brief set of the facts. So this was a 500 odd acre of land estate in Telangana, which out of which about 400 odd acres came to be acquired by the government under the Urban Land Ceiling Act and the Land Reforms Act. So there were about 99 acres which were still in dispute, which the government did not acquire. And in that 99 acres, the original owners seem to have given a power of attorney to a third party. And that third party entered into an agreement to sell with a cooperative society. And the cooperative society thereafter claimed possession of that property and transacted with that property by executing sale deeds.
Yeah.
Now, the affected parties who went to the Supreme Court in this matter were people who were trying to safeguard their possession based on those sale deeds, and saying that the government and its instrumentality should not take any adverse action against them and not to disturb their possession.
Correct.
What the court observed in this very interestingly is that yes, you do have sale deeds, but you've not checked what your predecessor in title had. They did not have a sale deed. They only had an agreement to sell. So therefore it was only an executory contract. Now, on the basis of an executory contract, you are now saying that I am holding title and valid possession. So all of these threw a lot of questions around the rightful nature of these claims.
Yeah.
So it is in that context that the Supreme Court said that your title deed alone is not enough, and which is the rule of law in India. And this is not just peculiar to this case. This case was decided, if I'm not wrong, in March of 2025.
Yeah.
And in April also there was a similar case in Gopi, where the Supreme Court again made a statement in passing where it said that you cannot you can transfer whatever you have by way of a sale deed. But if you don't have anything, you can't transfer anything.
Actually, this is what I find very interesting because it touches on the point of the chain of title. So you have to see that, okay, today I have my right to title is arising from this document, but where did that document get it? I mean, the transfer that happened in that document, the person who transferred it, the seller, where did they get their title from? So really going back and looking through the entire chain and verifying title in each of these cases.
It's a very interesting point that you brought out. Yes, you need to establish a chain of title. And this is based on a legal maxim which all property lawyers follow, that you cannot transfer what you don't have. So that is the thumb rule as far as property law is concerned. And therefore it becomes most crucial in real estate especially, that you need to establish a clear, unbroken chain of title to the earliest available known route. The reason why we need to do this, unfortunately, in India is because the state in India does not guarantee title. So there are jurisdictions like Australia, New Zealand, Singapore, where they follow a system called the torrent system, where once a title is registered in their central registry, then the state itself guarantees that title, which essentially means that tomorrow, should anybody question that title also, the person whose name is recorded and who is in possession, he will be unscathed.
As opposed to a choice of buyer beware.
As opposed to an option of buyer beware. Right? Because what we follow in India is what our English counterparts left us behind with, which is a system to establish title through an adversarial system, which means that at any point in time, a person can question your title. And if he questions, then of course the burden is upon him to show that he has title. But it is also your burden to
prove that you actually...
Is adverse possession the typical grounds to dispute? Say if you don't have some chain of title or inheritance dispute, is it that's the only...
Adverse possession, so I'll come to adverse possession. It's a good thing that you brought out adverse possession. This chain of title in India is, again, like I said, it needs to be established to the earliest route. Sometimes it needs to go back to 30 years, sometimes it needs to go back to 60 years, sometimes even before, if you're dealing with jurisdictions like Chennai or Bombay, because these were presidency towns. These towns have records maintained right from 1800s.
Right, 200, 300.
So therefore you are able to establish the chain of title. I have seen instances in Bombay where chains of title could be established even from 1800s. But the good thing that we also have in the Indian legal system is a statute of limitations. So to a great extent, and I wouldn't say it is foolproof, but to a great extent, the statute of limitations acts as a touch point for us to establish how long do you look back.
Yeah.
And the reason why I say this is there are two provisions under the statute of limitations. This goes back to your question on adverse possession.
Right.
So you can establish title through adverse possession, provided a 12-year possession has been retained uninterrupted, visibly
Right.
and known to the original owner.
Right.
So that is a 12-year period that is prescribed by the law for private individuals.
Right.
But now if you're dealing with the government, for instance, because there
Yeah.
are several instances where private folks squat on government
Land,
property
yeah.
and then try to claim adverse possession. So for there, the threshold has been increased. It's been made 30 years. So that's why typically in title due diligences, you try to establish chains of title for 30 years. This is the general
Rule,
benchmark. But mind you, India is a country with every state having its own peculiar set of
Yeah.
laws.
Right.
You have agrarian reform laws. You have laws which safeguard tribals and scheduled castes. These are special legislations.
Yeah.
And when it comes to special legislations, these rules of 30 years many a times are overlooked. Because ultimately you're also looking at the purpose for which these
Right.
legislations were brought.
Right.
And if people are trying to thwart that through adverse possession
Yeah.
or not taking benefit of the fact that people are not educated,
Yeah.
courts in those instances come down heavily, and therefore
You can't litigate a Panchami land grant dispute or
Yeah,
adverse possession.
yeah,
That
yeah.
is not solving the issue it is
yeah,
intending.
so therefore 30 year is a general rule, but on a case to case basis every property will have differing rules
Right.
which
So-
need to apply for
Yeah.
investigating title.
I think the curious thread we sort of also abandoned there was the Singapore Australia example,
Yeah.
where the government guarantees for the buyer sort of essentially enforcing the legitimate expectation that whatever diligence you had on the date of purchase is all the diligence that you will have to worry about as a buyer. Sort of here is again where obviously in legal terms that's a beneficiary system for the buyer, but as a non-legal trained economist, what I look at it is, okay, this is the state picking an asset class to encourage investment in. It's sort of pushing liquidity into one or the other. It's the same reason you can have a deposit insurance corporation that guarantees retail deposits in the event of a bank run. It's generally to encourage people who are the retail initiator, purchaser of the property of some kind or an asset to have more of that asset. And I'm wondering why we haven't done this here. So do we...
See, like I said, document management systems were more formalized and adhered to only in presidency towns previously.
Yeah.
So it's not a public finance or a philosophical choice. It is just we cannot enforce this system if we want it.
Not really. So the government is actively, and not just the current government, governments prior to that have also put ball into motion.
Yeah.
Machineries across states are moving. We follow a federal system. Land is a state subject. Therefore, it is not enough that the central government puts out a dikkat that everybody needs to follow and they all fall in line.
Yeah.
Every state also needs to fall in line. They also need to expend that kind of money and establish their records, digitize records, ensure processes are in place to ensure that there is a common land registry in place. So across the country, that process is ongoing.
Yeah.
We'll talk about Maharashtra. There is a whole system in Maharashtra where most records are digitized.
Yeah.
Especially in city of Bombay, if you have the cadastral survey number of a land, you can immediately go online and check who the owner is. So these things are in place. Similarly, in Karnataka, you have your land record system where right from revenue records, survey records, registration departments have gone online. But again, it takes time.
So, but why is the registry instrumental in having some kind of, say, buyer protection policy?
See, it is not about the register.
Or some system.
The register. It is important because otherwise it goes back to the adversarial system of anybody questioning the title, and then you having to
you need to have a single source of truth.
So you need
where
to
one
exactly.
person knows who owns the title for this land,
So
and then you trust that one person.
Just like technology enthusiasts like yourself who believe in the blockchain system, where once it is there and tokenized, then it is indefeasible. So India is also, India as well as each state within India is moving towards that. In fact, there is a recent registration bill that has come out, which is intended to overhaul the earlier Registration Act of 1908.
Okay.
And in that, they are trying to establish a central registry. Earlier registrations were only possible state-wise, but now they are also trying to explore interoperability between states. All of this is moving towards ensuring that a central registry is slowly getting established, because once a registry is established, then it comes to the question on who is going to guarantee title. Of course, there will be a tussle then also between
the
state and state.
Take on this, central government versus state government.
Yeah, because whether the center is going to
it has to
bear
be
this cost, or is it going to be the state? So that conversation is going to come. But there are still issues with that model that has been proposed currently, because it is giving a lot of power to registering authorities. It is giving power to registering authorities to decide whether to register or not. The whole reason why we are slowly moving to technology and making things automated is to avoid that human element. But with the new bill that is proposed, they are actually trying to again bring in the interference by a person, a group of people, etc., to determine whether a document needs to get registered, not registered. So
this is again introducing the inefficiency, which I feel is a lot like the toll gate system. You can actually just go with a fast tag, but there's a human being also
you
there.
still have a human.
And it's not even just the disguised unemployment, right? It's the Xerox shop business where you have these tech interventions that seemingly straight through process things because you see leakage and you're worried about transactions and incentives. But then there's an operator for this computer, the form filler.
See, but that's where I believe the court system in our judicial system will intervene. I did mention about K. Gopi case. K. Gopi case was an interesting case because in Tamil Nadu, there was a registration rule which allowed sub-registrars to refuse registration unless the person who was presenting the document for registration was able to establish the title of his vendor. Which means that he needed to either provide his previous sale deed, he needed to provide an encumbrance certificate, he needed to, if possibly he may have inherited it, in which case he will need to show prior revenue records to show that it is inherited.
You have to do N-1 titles.
Correct. Now, is a registering officer a legal officer to apply his mind, apply the legal principles and then decide a question of title and then proceed for registration? I would think not. And that is what the Supreme Court did in K. Gopi case also. It struck down Rule 55 because it said that is not his role. And because the Registration Act, at least the current one, does not envisage a situation where registering authorities are tasked with the duty of checking on title. Because that has always been the prerogative of a civil court. And the reason why I'm saying it's a prerogative of a civil court, it's really not a prerogative, but the civil court is administered, the justice is administered by a trained person, which is a judge. There are rules of evidence that come into play. So it is not based on just looking at a document and being satisfied that a judge goes ahead and passes a dictum. Evidence is appreciated, all evidence is not considered, you need to prove certain evidence. So it is through that entire process that it is determined whether somebody is the owner or not.
Which the sub-registrar is not equipped to do.
Exactly. So I suspect, while if this law becomes, if the bill becomes law, I suspect courts will come down heavily on it. Because it's taking, again, it has two issues. One, it is putting powers into a person who is not equipped to do it. And second, of course, it is again bottlenecking the entire process.
And then it's still you can only do so much for retrospective repair, right? The only thing you can do is from now on. Already, for instance, if we're very clear that a sale to an agreement to sell is not registered, is not proof, and that you have a registered deed and all your registered deeds are on an interoperable registry, then from here on you cannot have disputes at least about whether transactions were conducted.
Correct. And therefore, still the rules of law will continue to prevail.
Right.
Because it still means that once somebody has got a registered deed and he's recorded in the central registry and hopefully a state guarantees title, if he were to transact further, he still needs to follow the rules of practice,
Right.
which is essentially transfers of title need to be done through registered instruments.
Yeah.
So because these are rules which are there in the Transfer of Property Act, the Registration Act, which says that if you're selling property to another person, then it has to be by way of a deed which is registered with the sub-registrar of assurances. And if it is not, what will happen is what in Mansoor's case that happened, where the court said that you are holding title which is defective.
Right.
Yeah. So actually coming back to today, like what should the common man, like really, if I own a house, what do I need to worry about now, or how do I ensure that the title of my house is safe for this agricultural land I purchased?
See, there is no shortcuts to this. It's like if you have a ailment, do you self-medicate or you go to the doctor? It's as simple as that. You need to go to a lawyer because these are professionals who are trained to ensure that you are doing the right things, following right procedures, so that going forward, what you have continues to remain a marketable product. Because ultimately, why are you buying a house? It's not just to live. You're also looking at it as an investment, maybe to raise finance, maybe to sell it, earn some money, make a profit. It's with all of those ambitions that one buys property. So when you're putting in that kind of investment into it with these goals in mind, it is, I would believe that it is most important for you to do
any
your...
person who has allocated that percentage of their net worth to an asset class should diligence it. And in fact, most people typically rely on a bank lawyer. You take a loan anyway, it's good for taxes. The mortgage lawyer will check it for you. But then again, it's better than nothing, but you think you're the principal and they're your agent, but they're their own principal, and the mortgageability is not necessarily the marketability.
But what you brought out is quite important, and that is actually a quick, at least to some level, a safeguard that most common people can do. Take a bank loan when you're buying property, because
at least one level of diligence is
because
already done
banks, as part of their standard operating practices, always have a lawyer, an empaneled lawyer, who would give an opinion on the title to the property. I'm not saying that those title opinions would be foolproof, because again, there are several factors that come to play here in terms of the economics that the lawyer is being paid for delivering that product, his time, his availability.
It's a volume-based business.
It's a volume-based business. So therefore, the level of due diligence may be sometimes lacking, but it is better than nothing.
Correct.
Because for the bank is trying to de-risk their entire loan portfolio to some percentage threshold that they're happy with.
And also the perspective of the bank is to ensure their asset class, the mortgage, is actually taken care of.
And they already have multiple risk factors. They have different tranches of loans anyway. So a bad title is a bad loan it's just one of 12 ways a loan can go bad. So it's totally different.
That's right. So that's why I said it may not be foolproof, because the thumb rule in lending is you're not really lending based on the security interest that you're getting. You're lending on the credit and credibility of the borrower. So you're looking at his ability to refinance. You're not. No bank is looking at actually enforcing, because that is the more cumbersome, painful process.
And they may not get good price also.
They may not get good price also.
Fire sale is a fire sale. It's a fail sale.
So therefore, and when you're looking again at volume business, in 100, if 10 fail also, if 90 have performed, you're good.
That's also why we don't let normal people write checks to startups, because the startup business is write 100 checks and then hopefully one like jhana will do really well. But you don't let everybody do that, right? No, that's very interesting. For me, like, what I'm trying to figure out is, obviously people are not protected right now, and obviously something needs to happen. But for me, this is also, so I come from a background of thinking about, what straight through processing can look like, and I think in India we've done a lot of very good stuff in terms of interoperable marketplaces that have proof of identity, be it ONDC or UPI. And what I keep coming back to is why this is a subjective process rather than a checklist. And I understand the checklist will always have this infinite set of, okay, what if it was court auctioned? What if it was a Waqf or a Hiba land? Or what if it was any of these 11, 12, 15 other things? But it seems to me like the overwhelming majority of property can be fairly uncontroversially checklist diligenced, that there is some kind of 17-part form. Okay, was there an encumbrance? Was there a transfer certificate? Was there an inheritance, a death certificate? If it was transferred, was it a registered deed? If there's no deed, are these secondary documents available? Whatever it is, but it seems like there is a flow, and that you have to pick up that flow for each jurisdiction or localization. Why is there no system for this? Why do we still rely on great, smart individuals to figure this out for me?
That's also because of the multiplicity of laws that govern real estate.
Right.
That's actually the reason. You don't have one legislation governing all property transactions. You have your personal laws that come into being. For inheritance,
Right.
If you're a Muslim, it's a different law.
Right.
If you're a Hindu, it's a different law. For a Christian, it's a different law. If it's a special marriage, that's a different law. So there are so many laws that come into play which impact title and its transferability. So it is not a case that everything can be checklisted. So depending on the facts of each case, the applicability of the relevant law comes into play. Of course, I believe that with AI and with a lot of these rules getting learnt by these modules, those rules could be applied to sets of facts. And it is not then just sets of facts, because those facts also need to be investigated through the processes that I mentioned. You need to check whether documents are registered. You need to check whether the chain of title is established.
Reading comprehension and interaction with the client,
but
asking for more documents.
But if modules are created which encompass these rules around real estate laws and are able to apply those directly to the facts, yes, life for lawyers will become a lot easier. I think most lawyers would be most keenly waiting for that day.
What is the difficult sort of parts of this where people like you get pulled in these big commercial transactions, where maybe the other parts of this where even the law doesn't know what the law is?
See, it's and I keep telling this to juniors who join our team as well. We are all able now, with the number of AI tools that are there, you really don't need to learn the law.
Okay.
You can put it on these modules and ask it questions, it will give you answers. But what comes with practice, and that's true for not just legal, but most professional services, is the experience.
So that's the intuition of where to look for the smoking guns or where to look for problems.
Intuition is one. The second is intuition of the result, intuition around the probability of what could go wrong.
So it's
in a process.
Could I let me try throwing some examples and tell me when I get the lawyering. But maybe somebody has inherited something, there's no death certificate, you look at it and you say, this person would be 101 years old, I think you'll be fine. Is that something like that? Or are you making subjective sort of evaluations and advisory where another expert of equal expertise could disagree, for instance?
So inheritance is a simple thing.
Right.
So that's not where the real lawyering happens.
Right.
Like you also said, it's either getting a heirship certificate or getting some family members to confirm that these are the only people.
Right.
But that is also not foolproof in India, because if there's an unborn child in a woman's womb, if it's a family property, that child also has a right. Now, who's going to figure that out? See, these are the challenges that we face in India. But then again, in these circumstances also, if time period has lapsed for more than 12 years or 30 years, there are a lot of intervening events to ensure that even if 12 years have passed and kids have become major, they have turned 18, therefore their limitations would have stopped, their ability to challenge. Those are the subjective calls that, based on the facts that are available, a lawyer applies his mind and tells his client what is the probability that this is really going to come, and if it does come, what are the safeguards that we have. So that's where the
Right. And
lawyer
no, absolutely.
role
And
comes.
even I feel real estate is perhaps specifically even harder for AI systems because already in India, what I see with so many well-read, really top of their practice lawyers is that not only do they have an edge in terms of like, generally thinking and reading fast and catching things really fast, which, all top of their field folks tend to do, they also have this almost specific accumulation of tacit knowledge that is acquired only through sort of experience and going through the ropes. And I feel in real estate, maybe there's so much that is not codified, not written down. There aren't even maybe a textbook that can take you through the latest RERAs
but
things.
most laws in real estate, especially the personal laws, are not codified. For example, the Hindu Succession Act. Hindu Succession Act has been codified only to the extent it has been set out there. Anything else, for example, joint family properties, karta,
Goes back
Has
to
to be
our
placed in the
uncodified.
it
common
goes
law.
back to Manu.
Right.
Oh, which is
Right.
So,
Okay.
so therefore, it is when the dawn of civilization happened and Manu
Yeah.
decided to set out his rules of
Yeah.
Manu's laws. So everything is not codified.
Yeah.
Muslim laws,
Right.
everything is not codified.
Correct.
There are things that are done based on practice, and most personal laws are actually prepared such that only certain rules are codified, and it is still left to the local customs that continue to be practiced.
Yeah.
For example, there are Muslims in India who continue to follow Hindu Succession Act. The Supreme Court has recognized that. Kachi Memons.
Yeah.
So there are these rules of law that need to be, and customs which are all not codified. And
Right.
I don't know how an AI model can
If it's
capture
If
that.
it's not written, then how
It's
do you
not,
train it?
absolutely,
Yeah.
absolutely.
correct.
Yeah. No, and I think that's like really part of the problem with real estate and some other parts of niche practice where, especially if there is emerging law, you have key legislations that have come up and now are being litigated clean, and you have two judge benches disagreeing with each other every other week. So how does somebody pick this up? Is it through failure and pain and blood, sweat, and tears?
See, real estate has always been a lot of hard work and lot of hours. Because, for example, if you're doing a real estate project, you cannot afford to have even one stone unturned when you have purchased land to do a large project with a large financing behind you. And suddenly you get a notice saying that my claim or right was not addressed.
Yeah.
Get me relief. Whether it is a valid claim or an invalid claim, a court is not in position at the threshold stage to decide, especially questions of limitation.
Yeah.
Because limitation is always a question of fact and law. So therefore, these get entertained. And if the person is able to even give a prima facie thread of evidence to show that his name was there in a record or his right was somewhere lingering,
Yeah.
because again, the idea of the court is to ensure that no party is put to harm. And if multiple transactions continue to happen, more people are put to disadvantage. Therefore, what courts would do also, they would also pass the status quo order.
Right.
Now think about the developer who has purchased this land with the view to do a development. He's bought the land, sunk his money. He has a financing behind him where he has to pay interest on it. So he's left in a soup. So therefore, doing the diligence becomes very crucial to ensure that all of these degrees are all picked up. I did mention about everything not being codified, but in day-to-day transactions, not everything has those complexities.
Right.
Yeah.
Right.
So actually, I wanted to talk about the role of RERA in this, because especially when you come to developers, we now have a regulatory authority specifically for real estate. So is there some more comfort around the title? Because I know RERA came about to kind of help home buyers, ensure against any fraud from the developer side. But I'm not sure how much it addresses the title.
See, RERA has put, earlier there was no specific regulator that one could go to if they had issues around buying an apartment, buying a plot from a developer. And now you have a single regulator who oversees this. So it is a big win. Maharashtra RERA has done a lot in Bombay, where a lot of things have been streamlined. A lot of rules in relation to creating security, forms of the agreement, enforcement actions, etc., pretty proactively done. Not all other states have taken cue. some states were at least a year back still in the process of formulating rules.
Yeah.
They hadn't formulated their standard forms. But Karnataka, for instance, has created rules, has standard forms, but still somehow there is a general perception that the enforcement of the laws relating to RERA are not stringent enough. I wouldn't say stringent, they are not put into effect as much as they should be when you're comparing other regulators like MahaRERA. So that is something that the general discomfort has been there as far as Karnataka is concerned. But that said, the rules of any development now mandate that certain basic check needs to be done before a project is registered.
Yeah.
For example, developers can't just take the full money from allottees and then vanish.
Right.
They need to first register their project. Without registering their project, they can't take a single penny. They can't take more than a particular percentage until such time you have a registered agreement for sale. And then thereafter, whatever timelines they have committed to the allottees as well as the regulator to complete the project are cast in stone. You will at most get a 1-year extension. But beyond that, there is no extension. So therefore, developers are also now mindful when they are coming to the table to launch a project. They are also in a state of readiness.
Yeah.
It's not like how earlier times where people used to take expressions of interest from multiple people,
Right.
as much as the full plot
Yeah.
amount, and then suddenly vanish. They wouldn't have bought the land, they would have got a single approval. But now to even register the project, you need to get your basic approvals.
Got it. But does registration, like if I purchase in a RERA approved project, does that mean the title is kosher?
See, RERA does not guarantee title.
Yeah.
But what RERA does is that the developer needs to do certain basic checks, like I said. So one of the things is that he needs to provide a title report and upload it on the platform so that the general public who's looking at the project can also look at that.
Yeah.
He also needs to disclose which bank is the project being financed by.
Yeah.
See, all of these give comfort to a purchaser.
So it's transparency, but more so maybe for the timely conduct of delivery and conveyance
Absolutely.
than for...
Another statutory safeguard that RERA provides is that now there is a indemnity which is without any limitations cast on the developer as far as title to the land is concerned and the project is concerned, which earlier was always subject to contract.
Yeah.
But now there's a statutory mandate that if you have purchased, he needs to stand behind title.
Yeah.
Of course, the RERA also envisages.
So this is the land building separation.
But RERA also envisages that this guarantee on title from the builder can also be insured. But insurance policies are not currently so prevalent, guarantee for title in the market. So that is still an area still developing.
Yeah.
But my point is that we are moving in the right direction.
And private markets are sort of building operations for this. And I think like until we have that registry or credential or token that is publicly available, like the other interesting thing is like now I live in Bangalore and I see the amount of real estate activity. It's every day seems more than the previous, and you even see a lot of new builders, small name builders that are propping up. And I think like there's so much real estate purchasing activity, and especially in big cities like Bangalore, the buyers are getting more and more sophisticated, but the process remains sort of a little frustrating. There's still sometimes a Tahsildar office or a Katha.
Like I said, the government is moving the machinery to ensure we reach a state where things are all automated.
Right.
Now there's a lot of hue and cry in Bangalore around khatas not being there.
Yeah.
But the government needs to start at some point.
Right.
Yeah.
If you keep saying that, no, you can't have this, you can't have this, then there is no end to this. So the government needs to start somewhere. So that's why they have now introduced the e-khata system. The good thing about the e-khata system is that, of course, it is creating a lot of heartburn for actual transactions to conclude, because without an e-khata, you can't register. But think about the benefit of it. If you have an e-khata, only you can register.
Right.
Which means that there is already one automatic check.
That's happening.
That is automated and happening at the back end.
That is still strange in the sense that the check for the revenue record shouldn't have to be separate. So I guess like the sort of systemic problem we have is that there is so many incidents or spaces where land is interacted with by the government. It might be in a revenue setting, it might be in a disputes and court setting, it might be now in a sort of regulatory authority for builder setting, and each of these have different sort of
Touch
purposes
points, yeah.
and civilian touch points.
In fact, good you mentioned, that is something that the central bill for Registration Act is intending to address.
Right.
They're intending to actually connect it with all the other departments.
Right. And therefore, this is
income tax department,
right,
Yeah.
exactly.
revenue records,
So you
all
just see it's your patta,
get automatically
your
applied.
supplementary
Yeah.
documents.
And to be fair to the current government in Karnataka, the government is also moving towards that.
Right,
Today,
absolutely.
if you ideally, if you are doing a registration today and you have an e-khata and you're selling your property to Priya, Priya does not need to thereafter go to the corporation and get her khata updated because it has already happened at the back end.
Straight. I mean, but that is the point of having a database. I want to stress that
which is not
it's
there
good that
earlier.
we're doing these things, but these are like 80s reforms that we are bragging about in 25, right? Like I know it's when we start at a point of crisis and things seem untenable.
We are looking at Bangalore only as a single city.
Right.
But for the government, Bangalore is only one limb of the
Absolutely,
largest
absolutely.
state.
Yeah.
And we should also be mindful that governments are also like corporations. They need funds.
Yeah.
Funds need to come from the center or funds need to be raised. There are state governments that I know that center does not support at all for political reasons, ideological reasons. Those states have actually raised funds through bonds, infrastructure bonds, etc., independently to raise money to create infrastructure.
Yeah.
Absolutely. I mean, most infra is the Japanese loans all flow into state governments directly. But I mean, that's the standard theory of change problem, right? Like India is a megalith of a thing and so on and so forth. But my point isn't that, that we should do more, which is a generic platitude you can say in any situation, but rather that the approach we take, right? Again, there's a question of doing it by design or doing it post hoc by resolution, adversarially, relying on individuals to sort of create equilibria through these clashing interactions. And, part of like, for instance, how we would think of this in a policy space is to say, okay, if there is only one transaction happening and all of these things are emit from this transaction, then they should be automatic records produced by the observation of the transaction itself, right? So for instance, I should be able to see the escrow or some kind of bank transfer or whatever the modus of transaction is occur, and the registration and everything else should be sort of derivative of that event occurring, right? And I should be able to go to a registrar's office, put my thumbprint down, do the transaction, and that should be everything.
Which is where we are headed.
Right. So, and that's...
How long do you think it will take for us to get there?
I like I told you need a buy-in from all the states.
Yeah.
It's not something that the center can just put a dikkat and everybody has to fall in line. Of course, the Registration Act is a central legislation, but the Registration Act is also, it is part of the concurrent list, which means that the states can also legislate on it.
Yeah.
That's why you have variations in requirements of registration state-wise. For example, an agreement to sell is not compulsorily registrable in Karnataka, but it is compulsorily registrable in Maharashtra.
Mm-hmm.
So there are those variations. So you need a buy-in from the states to create the machinery, to follow the rules. But I think in the next 5 to 10 years, we will be a completely different we'll see a completely different landscape.
Once we're past that and say we have some kind of an interoperable registry, then what is the dispute that I need to be worried about as a buyer? It's the chain?
After that, see, the chain is not going to get addressed until the state goes the next step after this.
Can't we just wait? In 30 years, it will solve itself?
Fully.
Right.
No, I think once you have the central repository, then you don't really need to look at chain of title.
No, I'm saying if you have a central
once you have the
repository,
central repository, then the state needs to give its buy-in to guarantee that.
No, I'm saying, let's say we transition into this world, but then in this hypothetical world, in 30 years after that, we don't have chain of title disputes, or is there still a source?
No, there should not be any chain of title disputes.
Because once you register it, that's the final title. And
It goes back to the torrent system of title.
Yeah, the state will reimburse.
We can have
compensate.
the proof of transaction. So then I guess you'll still have inheritance disputes or claims on property.
See, those will remain because, for example, a person whose name is on the registry, if he expires, he may have 2 wives.
Right.
In which case, the second wife does not have any claims, but her children will have claims.
Right.
Because they are all entitled to a share in their father's interest.
Yeah.
So,
But I
so
no
therefore-
longer have to worry about the marketability of property insofar as it is
you don't
achieved
need-
by commercial transactions.
Correct, and you don't need to go behind the title.
No, I think broadly, Mridul, what I'm sensing is that we have these problems for good reasons, in the sense that we work with a megalith, we have these federalist principles, and we have done a lot of work with land that has economic reasons, that has redistributive reasons, that has social reasons, and so on and so forth. So then maybe the path ahead is looking pretty good. So what is the transition? What are you just going to retire when the industry ends? What do you see happening in the world?
See, with all of this digitization and central registry systems, there is no retirement in all of this. What is only going to happen is more commerce.
Right.
So more commerce will happen. Therefore, people will get even busier.
And it'll be more seamless.
It will be more similar. It's just that a lot of this non-intellectual work that a lot of us spend a lot of time on can be avoided. You can actually devote your time to more challenging things, more stimulating things, and therefore it's a win-win. There's no question of retirement. And it is true for doctors, lawyers also. As we grow older, we taste better.
Just like whiskey.
Yeah.
And maybe legal, as you're saying, becomes more and more about where legal can be a source of optimization rather than merely compliance or record keeping. And like this is always the pushback I make against lawyers is that like if you look at when lawyers get paid the most, it's when they're least lawyerly in GC roles, when they're almost CXOs, and maybe a finance CXO is thinking about how to restructure the financial operations, or somebody's thinking about the logistics, somebody's thinking about the distribution, and this GC is thinking about the legal structure, the tax incidents, or where we're doing human resource hiring, where people are working out of, where we're.
I think the reason why you feel that way is because you're again looking at it from a lens of immediate apparent benefit.
Right.
You're not looking at it from a benefit which is not apparent. It's like audit firms. If you look at audit firms actually, for doing the audit, they don't get paid much.
Right.
But the biggest risk an audit firm does is issuing that auditor certificate, because the risk there is not commensurate with the reward. On the other hand, if you're a tax advisor is advising on structure, the benefit is very apparent to the client immediately.
I would push back and say it's not even apparent benefit. It's a question of positive versus negative benefit, right? It's whether my property rights are protected or enhanced. And I'm saying the protection of property rights is an unfortunate failing of the vulnerability of human systems, of relying on trust, on relationships, and relationships fail at times. Things need to be written down, codified. But it is a sort of stopgap measure, right? It feels ad hoc, it feels temporary, it feels like a band-aid on the situation. It feels obviously important for that litigant or that person whose entire net worth is invested in the land. But as a policy measure, it almost feels like the way forward here is through is legislation, and legislation that cures litigation, right? Legislation that prevents gray areas that allow litigation to arise.
But that's always been the case. For example, you earlier talked about RERA.
Mm-hmm.
Ever since RERA has come into force, earlier the number of civil disputes in relation to projects, apartments have reduced. They're all going to the RERA forum, or they're going to consumer disputes forum, where the redressal mechanism is much more streamlined. Orders need to be passed within 30 to 60 days. So there are clear timelines within which you will get an end result. Mm-hmm. On the other hand, if they continue to languish in civil courts, we're talking about again people waiting for justice to be delivered for years together. So therefore, it is important that these systems are brought into force through legislative mechanism.
Correct.
And that is only something that can be coming from the state as well as the center.
Right.
And like I was saying earlier in the beginning, unless you have these kind of laws and rules of conduct, commerce can't excel.
Right.
Yeah.
So the interference through legislative measure is most important.
So basically, cooperative buy-in is market making.
Yes,
It will increase liquidity, transactionability.
Yes.
So from a consumer's perspective, if we are buying a home or even renting a home, what would you say are the checklist of things that of course, go to a lawyer. But what is the checklist of things you kind of keep ready, or you think about, or you ask the landlord for these types of documents, or if you're purchasing the property, the seller?
There are standard uh, uh, checklists that need to be adhered to while investigating ownership to property. And there are actually judgments by courts also which have pulled up lawyers where they have issued title opinions but not followed these practices. So some of those practices are, one, we discussed initially, establish a chain of title,
Yeah.
which is unbroken without any other
Encumbrance.
clouds on title, etc.
Yeah.
Second, do an encumbrance check.
Yeah.
In Karnataka, Tamil Nadu, Telangana, doing an encumbrance check is easy because they are in a way digitized. At least the sub-registry issues a certificate. But in places like Maharashtra, Delhi, there is no certificate that is issued. So therefore, you need to go and do a physical search in the different registries of the physical registers. Again, hopefully someday it will all get digitized. But until then, this is the process. But it is still an important process because what the law says is if a document is registered, any person dealing with that property is deemed to have notice of that record. So therefore, you can't go and buy a property where maybe 20 years below down the line, there was a transaction which is registered, which is detrimental to your title. It is deemed that you knew about it and still bought it.
Because it's your obligation to go and check.
It is your obligation. So then the next thing is to check for litigations. Check for litigations, again, the problem in India again is that no litigation for property are maintained basis property.
Right.
They're all based on the names.
Right.
Yeah.
Now again,
So
names
there's no way to
also,
link or tie them
there's
directly.
no. Now many a time there are errors in recording the names in the court systems.
Even a spelling mistake can
Even a
throw you
spelling
off.
mistake can throw you off.
Yeah.
In India, we have common names.
Yeah.
If you try to search for a particular name, Lakshman, for example, I'm just saying, you'll get thousands of it. So now, deciphering in that thousand hit, which is relevant to you, again becomes a Herculean task. But still, nonetheless, we still do it because today these are the only
Safeguards you can have.
these are the only more rules of conduct that need to be followed to ensure that we are acquiring clean property. The next one is to issue a public notice. So generally, whenever we are buying property, we issue a public notice because the reason why people issue public notice is to establish your bona fides, that I am buying property, let the world be known. I want to genuinely know if there are any claimants and I am paying value. If you do this, tomorrow, should there be a unregistered claim against the property, you always have a defense under the law to say that I am a bona fide purchaser without notice, my title will remain good and I will not be affected by that unregistered claimant. So these benefits happen if you try to establish these things. The other thing that we do as part of title investigations is also to check revenue records. We briefly spoke about Khata.
Yeah.
Now, Khata is something which is unique to Bangalore, but in other jurisdictions you have other revenue records. We try to establish through the revenue records who was in possession, who was the owner, because again that helps to corroborate whether the chain that you have established is accurate or wrong.
Yeah.
And once you do these checks, then you are in a good position to say that the ownership is good and marketable.
Yeah.
But that is not very common when you're doing leasing transactions.
Yeah.
Again, if you're doing a 30-year lease,
Yeah.
it's as good as owning the property because
Yeah.
you're looking at it long term. You're really not looking at
You measure it as a down payment and a
Yeah,
mortgage,
correct.
buying it off.
Yeah, you're as good as you want to be the freeholder there.
Yeah.
So therefore, in those instances also, you end up doing all the works that you would have done as though you were buying the property. But most transactions are not like that.
Yeah.
In the city of Bangalore, for example, office leases that happen, they are for 5-year terms, and you're dealing with reputed developers, owners, builders who have the wherewithal to stand behind the commercial arrangements that they enter it with you. So tomorrow,
The moment a game becomes a repeated game, then it
so
solves itself.
tomorrow, if a claim were to come also, you know that the contracting party, in terms of your lease arrangement, has the wherewithal to ensure that your possession remains
Yeah.
protected. They will make good any loss that you suffer. Therefore, in those instances, you don't need to do a deep dive. But you can at least still, in those cases also, we advise clients that you should still do a prima facie diligence, which is to see, look at their ownership document, look at where their revenue records have been updated, because these prima facie establish that we are dealing with the right owner or not.
Yeah.
But most importantly, in leasing transaction in Bangalore, and not just in Bangalore, across the country, what I must say is that many people are not aware that most leases require registration. So any lease above 12 years is compulsorily registrable. But people are so adept and used to just signing documents. 4 years, we'll just pay nominal stamp duty. We won't register it. But what happens as a consequence is that tomorrow, if you have to enforce your rights under these contracts, a court is not going to recognize it. Because if it's a lease for about 12 years and it is not registered, in the eye of the law, it is as good as a transaction has not taken place. So therefore, there is no question of you being able to show this and the provision in the lease to say that I should get these rights. So therefore, it becomes important to stamp, register. Stamping is also equally important, even if it is less than 12 months. But still, it requires to be stamped, because if it is not stamped, again, the court will not immediately accept it in evidence. In which case, you will need to first pay penalties. In Karnataka, you have to pay 10 times penalties. So it is always best to just follow those rules of conduct, pay the stamp duties, registration fees, and then conduct your business. Because what is more and more happening with the whole digitization coming is that all of these records are getting interlinked with different departments. If you register a lease also, immediately, if you're going for a operation license, eventually we will end up there. The corporation will have access to your lease and check whether it is registered or not. And if it is not registered, that may be one of the reasons why your request for an operational license will be refused. So it is all good practices that you can adopt.
These things compound.
And if you don't, these things compound.
Makes sense.
No, I think that's actually a brilliant note. And what I'm hearing is there is some difficulty on the easy end of the spectrum, which we're doing a decently good job, and increasingly so by replacing with process, but also systems where consumers can access their records, where consumers' identities can be verified, and so on and so forth. And that there will always be this other end of diligence where you're providing this sort of structuring advice, this optimization advice, doing a lot of sort of strategic thinking for the client, looking for their best interests, ensuring the commercials they understand are indeed what is recorded. But there seems to be sort of this bridge in the middle where maybe consumers need to know their rights. In the least, maybe they should use bank lawyers. And maybe there's still something unserved in that gap where there is 70% of these transactions have this checklist of the reasonable complexity that can be studied and mapped for each jurisdiction or each locality. And maybe we do need to do something for these consumers, at least for those next 20, 30, 40 years when the government has not yet sophisticated, but folks like Bangaloreans have, and they expect a certain ease and way of doing things. When I transact on my dematerialized account now, I do it all from my phone, and it's instantly settled and all moved, and there's no question of dispute ever whatsoever. So maybe one day we'll get there. But yeah, I wonder what you think about the technological transition for this middle group. What do we do to these? And one thing we always used to believe in public health, right? When I used to work in public health, is we had this problem that people would either self-medicate, as you were saying, or go into compounders. And my former boss, Santosh Matthews, one of the most delightful policy thinkers I've always had the pleasure of interacting with, always told me, don't believe research that says that people need to be taught to approach doctors. The moment healthcare becomes accessible, people go to doctors. So really, maybe the thing is for most people, like I know as the service provider, we always like to think, no, there is a behavioral change that is required. But ultimately, most things are dictated by expected cost and benefit, right? And maybe right now, the cost of the procedure or the inaccessibility of the service for most transactions is high enough that it is not worth it for the expected dispute probability of the consumer. And, maybe implicitly, people are making rational choices, and the law also is at fault in that it has not been accessible for simple transactions or relationship-based transactions. Or at least so far, we've had a lot of ability to rely on trust as a way of conducting real estate, which maybe doesn't exist anymore in a more globalized, cosmopolitan, fast-moving economy. So I'd love to hear what you think as a concluding note. Do you think is the role of the computer and the human in this system?
See, I think a lot of models are coming up now where there's a lot of interface where these models are able to provide the basic advice in relation to legal queries that are being posed by consumers. I am also aware of platforms which use a lot of tech now to actually do title investigations as well. Of course, there are caveats and limitations that they have stated so expressly in those platforms, also saying that we'll only look at 12 years. We won't be able to do beyond that. That's also, again, not a function of the platform. It's because the records are not available. But I think tech is moving towards bridging that gap and ensuring accessibility. And I wouldn't say affordability. Accessibility is getting increases because affordability will still be a question mark, because as these models also scale up, their costs, because all of these back-end operations also require a lot of capital investments, and therefore their costs also need to be recovered from consumers. But accessibility will increase, and I think I would also agree with what Santosh said, that more it becomes accessible, more people get educated about it. And more you get educated about it, you would, of course, want to know, do your reading, but then you will definitely reach out to the experts as well.
Right.
So I think there's a great role for models like yourself to provide to consumers in making all of this a lot more accessible, reader friendly.
And also, when you approach the expert, then finally you're a lot more prepared. You come with all your documents, you've already got them pre-checked, like you asked for in Karnataka the khata. So it reduces kind of the element which they're actually coming to the lawyer for. Like you said, a lot of the drudgery work moves out of the window, and you kind of focus on the more analytical piece.
No, and in fact, it will help lawyers also, because see, lawyers are already actively using tech tools. There are a lot of law firms who have built their own models. In fact, Trilegal is one of the front runners there, where we have models like our own models, which are similar to a ChatGPT or a Harvey, where we can load documents within our own environment to ensure that confidentiality is maintained, get speed in terms of legal research, questioning the AI platform to enhance value. And something we keep telling our juniors is that if you don't scale up quickly, the AI will replace you, because what today also is happening is that a lot of these AI modules are actually I would say at par, or sometimes even startling us in terms of the output they give as compared to 1 to 2 year trained associates. So therefore it is something for all us lawyers also to reckon that you need to move with this, try to adapt it as much as possible, because once you adapt to that change, then you will also ride the wave.
Absolutely. And I mean, it's also the tools have to get there. And, in programming, we have really good tooling. And I have seen myself how much further I can now do the work of 2-3 people, because the AI is just superlative at executing. Once there is an architecture and a design and all the strategic choices have been made, I can just describe the rest in a pointed format, and almost from notes and comments get the full form back out. And obviously the law is a lot harder to do that for, because in the law everything is so confidential, it's sensitive, it's a proprietary invention. The huge benefit we had in programming is that we open sourced everything. So you have some of the most premier code bases with the best writing freely available on the internet. So the AI has already read it. But as we were just talking here, it's not just that legal information is proprietary, confidential, etc. It's often that the law is not even written down, and it's to be decided in the courts when it arises.
See, but one thing not to not promote AI, but one thing is that the lawyer-client privilege I don't know how the AI model is going to
Right.
is
And
substitute
that I
to
think that we have really good advances in
Yeah.
local models and deployable systems where you have complete ownership of the weights, data, etc. Right. So then you can think of it as, does the lawyer use Microsoft Word? In that case, that is a higher risk operation than using that local model, and that's what we do for a lot of our have done for example, some of the courts we work with is we create that closed off environment where then you have a tool that is far safer than Microsoft Word or Zoom, right? Lawyers just don't realize that because Microsoft Word is not something applied or legal in mind, that doesn't matter. It's the same text, you put it there, it's auto saved to the internet. They've had the same data access as the other AI tool has. It doesn't matter that the AI tool gave you feedback or comments on the input. The question is, what did it read? And the answer is the same thing, right? So I think we'll definitely find a way to work privilege, because, for instance, in programming we have that problem as well, which is we are giving it our best IP and telling it to work on it, and that's our entire valuation as a company. So we care a lot about ensuring it goes nowhere. So I think that these kinds of systems will be highly personalized, highly secure, because it's also such a companion, right? Even more, it's a collaborator, and like when I work with the Claude or I work with Gemini, genuinely it has made my life so much more pleasant. I can worry about more interesting things than whether the button turns green on some cursor going there and the cursor pointer goes from this triangle to a little finger. I can instead build the AI systems and let Opus make buttons for me. Right? And I think we will get there in the law. I think it will be slower than other fields because of this data problem that so much is sensitive and not written down. And especially places like India, you have environmental law, you have your IBC, and you have your real estate law. The law is being made.
Multiplicity of laws.
So I think that's the journey ahead essentially. What we need to do is not just build for the future, we also need to build for the present. So we also have to still, until our registries work and documents can be easily procured and verified, handhold an increasingly frustrated and economically sophisticated consumer population that still works with the same government system as 30-40 years ago. So I think that's what that's the gap that folks like us do, where we bring people or like you to scale and distribute what someone like you can do for one person.
Absolutely. I think these kind of tools that you guys create will actually increase our efficiencies. Our efficiencies increasing means we can take on more work, and therefore our access to more people
you become more accessible. And actually with that, the number of people that want to use the service also automatically explodes. So
it's a win-win.
I think that's sort of
I think that's a great. I've had a really lovely conversation. I think this is as pleasant a conversation as I can imagine having about real estate. So, Mridul, thank you for convincing us that your interest is truly interesting, and for a moment letting us all astray into the world of real estate. It sounds complex and very daunting, and we're very happy to share it.
But the future looks bright with all of the work that the government is doing on digitization.
See, I believe we have to be always optimistic. And unless we are optimistic, things are not going to be working out for us. So always be positive and everything will work out.
Okay, thank you so much for sitting down with us today.
All right.
Thank you.
Thanks.